Well, welcome everyone in here and out there. We are fortunate today to have Commissioner Janet McDonald chairing this CPD. Prior to her appointment to the New South Wales Industrial Relations Commission, Commissioner McDonald practiced as a barrister in the fields of employment and commercial law. She was also recognised as one of the preeminent practitioners in the field of costs, having been a legal costs consultant prior to being called to the bar. Commissioner McDonald was regularly briefed in cost disputes and appeared in a number of landmarked cost cases. She was a member of the Bar Association's Costs and Fees Committee for over a decade and remains the author of the commentary to Part 42 of the UCPR in Thomson Reuters' New South Wales Civil Procedure Handbook. Thank you, Janet.
Thank you, Jackson. I'd first of all like to acknowledge the traditional custodians of the land on which we meet today. I'm here on the lands of the Gadigal people of the Eora Nation, and I'd like to pay my respects to Elders past, present and emerging, and any Aboriginal and Torres Strait Islander people watching this CPD today. As Jackson said, I previously at the bar practiced extensively in legal costs, but since August 2022, when I was appointed to the Industrial Relations Commission, I've basically had very, very little to do with legal costs. And so I'm going to be very interested in the discussion this afternoon because I understand that both of our speakers are going to be canvassing a number of the recent decisions in this space, particularly in relation to the legal profession uniform law. And most of those decisions, whilst I keep still an eye on what's going on and I've got a vague awareness of them, I certainly don't have the detail like I used to when I was at the bar. And interestingly enough, as we were just discussing the Industrial Relations Commission, it basically is a no-cost jurisdiction. You have to establish that there are exceptional circumstances to justify an order for cost. So it's somewhat ironic I would end up there when I had such an experience in cost, but nonetheless, I'm still interested. So our two speakers this evening, Katherine Hooper. Katherine practices in public administrative and commercial law. She acts for both private parties and government agencies and has considerable experience defending agencies as respondents to merits and judicial review proceedings. Katherine has acted in appeals against decisions of cost review panels. She's also recently appeared in proceedings in the New South Wales Supreme Court, challenging a decision of the manager of cost assessment to extend time to permit a cost assessment application to proceed. Our other speaker tonight is Jackson Rogers. Jackson practices predominantly in commercial matters and in general equity. He has a diverse experience in insolvency, both personal and corporate, and real property, including mortgages, as well as revenue and taxation. He's also a member of the New South Wales Legal Aid's Indictable Crime Panel. In recent times, he's acted on appeals from review panel determinations, and he's acted for a successful defendant in a matter involving a personal cost order against a legal practitioner. So the first part of this evening's presentation, I'm going to ask some questions of Katherine around cost estimates and the consequences of non-compliance with the legal profession uniform law disclosure obligations and law practices applying for costs for assessment of costs out of time and appeals to the New South Wales District Court and Supreme Court from cost review panels. In the second part, Jackson will be addressing overcharging and the supervisory jurisdiction of the Supreme Court, the retention of so-called dirty experts and the recovery of costs for those experts, and over-representation in court. Also the latest developments with charging for employed solicitors where firms act for themselves and personal cost orders. Time permitting, we'll do some Q&A at the end. So, to Katherine, to start. So Section 174, subsection 1 of the Legal Profession Uniform Law requires a law practice to provide, amongst other things, an estimate of an estimate of total legal costs. Can this take the form of a range, for example, $100,000 to $150,000, or does an estimate of the total legal costs mean a single figure?
Well, in accordance with the lesser-known ultra-modern approach to statutory interpretation, this morning I took a quick poll of the level 22 barristers on this very question. Now, it should be borne in mind that they generally answered my question by reference to the disclosure obligation of a barrister, and perhaps understandably so. Putting aside direct briefs, our obligation is less onerous than that of a solicitor. Pursuant to section 175(2), we have to provide the solicitor with sufficient information to comply with their section 175(1) disclosure obligations. Despite this, though, there was still quite a variety of views amongst the floor. Now, some level 22 barristers provide a range. Some give a single figure and they consider it a requirement to do so. Some say up to a single figure, and many say something like, I assume you've got sufficient information to comply with your disclosure obligations, but tell me if you don't. Some say it's not possible to give an estimate, but they provide their rates and the basis of charging. And one apparently says a prayer for victory. But anyway, your question asks about section 174 specifically. On the first slide, which is up on the PowerPoint, you've got relevant parts of section 174, and note subparagraph 1 requires disclosure of an estimate of the total legal costs. Now, in contrast to the former Legal Profession Act, the Uniform Law doesn't provide in its terms for a range of figures or estimates to be given. Under the Legal Profession Act, section 309 provided that a law practice must disclose an estimate of the total legal costs if reasonably practicable, or if not reasonably practicable, a range of estimates of the total legal costs and an explanation of the major variables that would affect calculation of those costs. So the change in the legislative text in the Uniform Law might be regarded as deliberate and evincing a legislative intention that an estimate of the total legal costs is to be distinguished from a range of estimates. Now, for any barristers in the audience or watching online, as I've indicated, our disclosure obligation where retained by a solicitor is in section 175(2). We aren't required to make a disclosure under section 174, but need to provide the solicitor with information necessary to comply with their obligations. And it's my view that a barrister who gives a range, as well as, of course, information about rates and the basis of charging, will comply with section 175(2). But I don't suggest that a range is mandated. Coming back to the question, though, what about the solicitor's obligation? The question of whether the legislative text and estimate of the total legal costs permits a range is ultimately one of statutory construction. The words make up a composite phrase, which in accordance with settled principles is to be construed as a whole, not by reference to individual words filleted out and defined in isolation, and having regard to the text read in light of its context and purpose. Now, whether a section 174 estimate can take the form of a range was recently considered by Judge Newlands in a matter called Yates Biaggi and Andrew Price and Elizabeth Theodore. And we've provided the full citation in the list of authorities, which is in hard copy if you're here today, and for those watching on YouTube, we've attached it to a LinkedIn post. But I'll refer to this judgment as Price and Theodore. They are respectively Andrew Price and Elizabeth Theodore, a brother and sister who sought assessment of costs they'd paid to their former law firm, Yates Biaggi Lawyers. Now, the cost estimate in that case set out potential stages of the litigation, then anticipated to be a family law matter, and it identified, in relation to some of the stages, the costs that may be incurred by reference to a range. It separately identified possible disbursements, sometimes also in the form of a range. It did not give a single figure, but instead the client, which here relevantly is Andrew, was required to add together the figures for the various stages, add the disbursements, and then add GST. And it wouldn't have been possible mathematically to calculate a single figure estimate by reference to this disclosure unless one selected, for example, the high-end figure in all instances where a range was provided. Now, His Honour Judge Newlands accepted the plaintiff Yates Biaggi's argument that a costs review panel fell into error in finding that that cost disclosure was not valid, including for reason that it didn't provide a single figure estimate. His Honour referred to a case called Crosby and Fiker, in which Justice Parker accepted in obiter that an estimate under section 174 could be provided by means of a range. His Honour Judge Newlands was the view that, well, that must be so, and that to expect a lawyer to estimate with precision a single figure was not consistent with the obvious purpose of the legislation. His Honour said, well, the estimate has to reflect the lawyer's best honest estimate, and sometimes it would be impossible for a legal practitioner to hit a precise figure otherwise than by guesswork. He continued that selecting the highest in a range, or possibly the midpoint, would not be an honest estimate but the product of a wholly arbitrary process. And therefore, His Honour didn't accept that a single figure is required under section 174, finding instead that an estimate by way of a range is still one estimate and can be provided by way of a series of figures made up of different components. Now, I note that his conclusion, that is His Honour Judge Newlands' conclusion, is contrary to the view of the Legal Services Council in its guideline and direction cost estimates, which was issued in 2016, and also the view of Dal Pons in his authoritative text. Now, competing arguments can be made about the issue of statutory construction that arose before His Honour, and indeed they were, and I won't develop those today in this seminar because it doesn't align with our purpose. But I note that best practice for a solicitor or a directly briefed barrister may nevertheless be to provide a single figure, and ultimately I think it's a matter for you.
Thanks, Katherine. That's a very interesting development since I left, that's for sure. Certainly it was always my advice that it required a single figure based on the Legal Services Council directive about that, but it's an interesting development. So, next question is, what statutory consequences follow under the uniform law regime where a law practice has failed to comply with its cost disclosure obligations?
So section 178 of the Uniform Law deals with the consequences for a cost agreement of non-compliance with the disclosure obligations. Subject to Rule 72A of the Uniform General Rules, if a law practice contravenes the disclosure obligations, section 178 provides that the cost agreement, if any, is void, and this has the consequence that costs will be recoverable only in accordance with the determination of fair and reasonable costs by an assessor, rather than in accordance with the cost agreement. Such determined costs can't exceed the amount that would have been payable under the cost agreement, and in addition, the client or associated third-party payer is not required to pay the costs until they've been assessed, and the law practice must not commence or maintain proceedings for the recovery of those costs until they've been assessed, or any cost dispute determined by the designated local regulatory authority. Contravention of the law practice's disclosure obligations may also constitute unsatisfactory professional conduct or professional misconduct. The meaning of the word void in section 178 was considered by the Court of Appeal in a case called Bingham and Bevan, where it was held that the word void is not used in the uniform law to indicate some absolute absence of legal effect. In that case, there was a paid if paid conditional type clause in a barrister's cost agreement with a solicitor, and that clause survived despite the cost agreement being void under the uniform law. I referred earlier to Rule 72A of the Uniform General Rules, and this rule applies if a law practice has contravened the disclosure obligations. It provides that the consequences of non-disclosure that are prescribed by section 178 don't apply in relation to the law practice so far as they otherwise would, in circumstances where the relevant authority, an assessor, a court or a tribunal is satisfied of certain matters. And those matters concern the taking of reasonable steps to comply, taking prompt steps to rectify non-compliance, and whether the client would not have made a relevantly different decision. There are other possible consequences under the uniform law of non-compliance with disclosure obligations, and I just mentioned those briefly. They include first, the loss of the presumption in section 172(4) that a cost agreement is prima facie evidence that the costs disclosed are fair and reasonable. Second, pursuant to section 202, in considering whether legal costs are fair and reasonable, a cost assessor can have regard to whether the law practice complied with its disclosure obligations. And third, pursuant to section 204 of the Uniform Law, a failure to comply with disclosure obligations is relevant to the liability of the law practice to pay the costs of the cost assessment.
Right. I might, if we have time at the end, there's a further decision that I'm aware of in the federal court, which has something to say about if the disclosure, if the failure to update an estimate occurs down the track, what the effect of voiding it is.
Jackson and I were talking about that today.
Is that the Wills and
Woolworths?
Yes. So we may return to that if we have time. But for now, let's move on to specifically consider a recent authority about whether a law practice can have its costs assessed out of time. Now, I know that it's been the view for some time that it hasn't been possible because Section 198, subsection 3 of the Legal Professional Uniform Law provides that an application for cost assessment must be made within 12 months after a bill was given to or a request for payment was made to the client, the third-party payer or other law practice, or the legal costs were paid if neither a bill nor a request was made to the client or the third-party payer. Subsection 4 says, however, that an application that is made out of time may be dealt with by the cost assessor if the designated tribunal, which is the manager of cost assessment, if the manager of cost assessment on application by the cost assessor or the client or the third-party payer who made the application for assessment determines, after having regard to the delay and the reasons for the delay, that it is just and fair for the application for assessment to be made after the 12-month period. Conspicuously absent from this subsection is a reference to an application of out of time by a law practice. So the common held wisdom, at least to this point, has been that the law practice could not apply to have their costs assessed outside of the 12-month period. So can they?
Well, the answer is still strictly no, but there is a recent decision in a case called Dive Lawyers and the Manager Cost Assessment that provides effectively a workaround. So prior to that decision, Section 198(4) of the Uniform Law was interpreted as only allowing the assessor, client or third party to make an application for assessment out of time. And that meant that a law practice or a solicitor couldn't. Now, in Dive Lawyers, the plaintiff was an incorporated law practice and it made 3 applications for cost assessment. One of those wasn't accepted for filing, and the first defendant in the proceedings, the Manager Cost Assessment, or MCA, advised the plaintiff law firm that it couldn't file the application because it was made 1.5 weeks outside the 12-month period following the last invoice that had been issued in the matter. And the plaintiff applied to the New South Wales Supreme Court for judicial review of the MCA's decision. The plaintiff argued the MCA should have accepted the application for cost assessment, referred it to a cost assessor to determine whether it was made out of time, and if the cost assessor said it was out of time, they, that is the assessor, should refer it back to the MCA to determine if it could be dealt with. And that argument was effectively accepted. Judge LKM reasoned, first, no part of Section 198 of the Uniform Law, or Reg 34 of the Application Regulation, permits the MCA to reject the filing of an out-of-time application for assessment. Second, Section 198 doesn't provide any explanation as to why a law practice is not able to apply for an extension of time, but a client or a third-party payer can. And while there may be some element of consumer protection, that doesn't explain depriving a law practice of rights given to clients and third-party payers. And a law practice, in particular a small practice like the plaintiff firm, was just as likely, His Honour said, to miss an important date as a consumer. His Honour observed that the parties identified in 198(4) who can apply for time to be extended include the cost assessor. But the cost assessor is not a person who has made an application for an assessment. He or she is the person who does the assessment. And His Honour said, well, there's no overt reason why the cost assessor would be making the application for an extension of time. And so he considered the terms of Reg 34 of the Application Regulation and found that the MCA is required to accept for filing an out-of-time application for assessment by a law practice. That is then referred to a cost assessor, and the cost assessor, when noting the application is out of time, should refer it or perhaps apply to the MCA to determine whether or not it is just and fair for the application to be dealt with after the 12-month period.
Interesting workaround. All right. So we aren't going to focus today, at least directly, with the practicalities of running or defending a cost assessment application, which is obviously a big topic, or with the review of cost assessments or the cost determinations to the review panel. But after we've gone through the review panel and the review panel's made its decision and issued its certificates of determination, then there are appeal rights either to the District Court or to the Supreme Court. So, which court and which court and whether leave is required depends on the amount of cost that's in dispute. So, what is the nature of the appeal once you get to one of those courts?
Well, Section 89 of the Uniform Law Application Act provides for appeals to the District or Supreme Court, and that's on matters of fact and law. 89.4, that is Section 89.4 of the Application Act, provides that an appeal is to be by way of rehearing, and fresh evidence or evidence in addition to or in substitution for the evidence before the review panel or cost assessor may, with leave, be given on the appeal. So the appeal is by way of rehearing. And the differences between this kind of appeal and a hearing de novo and an appeal in the strict sense are discussed in authorities including Gilmore, Finance and AS Theat. In an appeal by rehearing, the powers of the appellate court are exercisable only where the appellant can demonstrate that, having regard to all the evidence now before the appellate court, the order the subject of the appeal is the result of legal, factual or discretionary error. Now, the court, that is District or Supreme Court, on appeal from the review panel has all the functions of the review panel. That's Section 89.2 of the Application Act. In a case called Gazecki and McCabe's lawyers, Justice Baston, with whom Justices Leeming and Simpson agreed, said that the effect of this phrase, all the functions of the review panel, is by no means clear. So the court has the functions of the review panel, but the review panel in turn exercises the functions of the cost assessor, and the panel is required to determine the application in the manner that the assessor was required to. And His Honour went on to say that, well, it might be necessary then for the court to adopt different standards of scrutiny when reviewing alleged errors of law, as opposed to questions of fact, properly within the expertise of the panel. It's relevant also for me to note in connection with this question what Justice Baston said in another case called Amir Biaggi and EB, particularly it's paragraph 52 of that case. Now, His Honour's remarks are obiter and they were made in the context of considering an argument about whether the costs of the cost assessment, not sought by the firm before the panel, could be added into the quantum of costs in dispute for the purpose of deciding whether leave was required to appeal to the District Court. And His Honour said at paragraph 52 that unless there's a question of jurisdiction, there will generally be no appeal from a review panel with respect to an issue which was simply not raised before it. If a ground of appeal in the District Court were to raise such a matter, the likely response of the court would have been that the review panel cannot have been in error in failing to deal with the matter which it was not asked to address. Now, Judge Newland's weighed in on this in the case of Price and Theodore, that is on the nature of an appeal from a cost review panel to the court. And His Honour commented that the litigation before him brought into focus a number of well-known defects in the legislative scheme. And he said that far from promoting the efficient and effective resolution of disputes as to legal fees in a way that is simple and easy to understand, it is riddled, that is the scheme, with inefficiency and complexity. The most fundamental of those issues, His Honour said, is that the nature of any appeal to this court is, to say the least, obscure. Now, His Honour was very critical of an earlier grant of leave by Judge Montgomery in the same case, permitting the plaintiff to rely on evidence that the plaintiff, that is the firm, didn't put before the review panel. His Honour, Judge Newland, said that this had the practical consequence of the matter running as some sort of quasi-hearing de novo, where His Honour was invited to look for and identify errors of fact and law made by the panel, but including by reference to evidence that was not before the panel.
And so you've just mentioned in that case that there was leave given for further evidence. When can you adduce further evidence? When will leave be granted for that to occur?
Well, The leave requirement is set out in section 89(4). The court can receive fresh evidence or evidence in addition to or in substitution for the evidence before the panel or the assessor. That simply identifies the evidence. It doesn't set out the test. In the Price and Theodore case, there were separate applications by way of notice of motion dealing with the question of leave, and they were dealt with by His Honour Judge Montgomery. He granted leave in relation to certain parts of affidavit evidence of the solicitor on the record, Mr Farshad Biaggi, and he refused leave in relation to a purported expert report of a foreign-trained costs lawyer, a Mr Joseph Rose. Now, Mr Rose's evidence was largely in the nature of submissions and also a complete reassessment of the costs billed. And His Honour refused leave fundamentally on the basis that that document, the report, was a written submission and wholly inadmissible under the expert evidence exception in section 79 of the Evidence Act. But what that meant, though, was that leave was granted with respect to aspects of Mr Amir Biaggi's affidavit. The defendants, Andrew and Elizabeth, relied on responsive affidavits. The plaintiff firm put on evidence in reply to that, and oral evidence was given at the hearing. Now, Judge Newlands considered the proper approach to an application under section 89(4) in his judgment in the substantive appeal. And I think this will be useful guidance for practitioners, particularly wishing to resist applications for leave in the future. His Honour said that the court should take a strict approach to such applications and only grant leave, absent the evidence being fresh evidence, if there's very good reason to do so and it's in the interests of justice, acknowledging that as soon as such evidence is to be admitted, the appeal becomes something very close to a hearing de novo. His Honour said it would only be in the most unusual and special case where leave would be granted just because the evidence was not put before the panel, and because of the panel's decision, it could now be seen by the party that would be helpful to have the benefit of that evidence. In other words, His Honour said the focus should not be on the fact the evidence is additional, but it must be on why, as an exercise of discretion, a party should be allowed to upend the very nature of the appeal and basically start again before the court. And interestingly, on that approach, His Honour Judge Newlands was satisfied that the court's discretion had miscarried on the earlier leave application. And this was because the only reason given for the grant of leave was that the evidence was in addition to that before the panel. But as I've said, that's not the test. His Honour refused, however, an application made by Andrew and Elizabeth to set aside the interlocutory ruling, and he also refused global relevance objections to the admissibility of the evidence.
Okay, so what are some of the factors that a party might put to the court to get additional or further or fresh evidence in?
Well, I think that without being exhaustive, because the discretion is not relevantly fettered, the issues that might arise on a leave application would include, first, admissibility. The rules of evidence apply in proceedings before the district and Supreme Courts, even though they do not apply before the assessor and panel. There's arguably no utility in granting leave with respect to evidence that's plainly inadmissible. Second, and importantly, whether the evidence could have been put before the assessor and panel, and if it could have been, why was it not? Third, prejudice to the defendant. So would the defendant have conducted the case differently before the assessor or panel had that material been available? And last, principles of proportionality and the overarching considerations of case management in the Civil Procedure Act. Now, some of these considerations are identified by Her Honour Judge Gibson in a case called Yates, Biaggi Lawyers and Posh. Now, in that case, Her Honour admitted a very small part of the affidavit evidence of the solicitor, again, Mr Amir Biaggi. Most of the proposed further evidence in that case had either fallen away or it had been identified as, in fact, having been before the panel. On appeal from Judge Gibson, the Court of Appeal held, amongst other things, that Her Honour had not erred in refusing leave under section 89(4). Justice Stern, with whom the other justices agreed, found that Judge Gibson had correctly directed herself to the applicable law and considered matters going to the relevance of the affidavit, proportionality, and why the material could have been expected to have been produced before the panel. And Justice Stern said that as a matter of substance, these are matters that would probably be taken into account in considering in the exercise of discretion whether to grant leave. I note also that where an appeal to the District or Supreme Court is allowed on the basis of new evidence, particularly where, as in Price and Theodore, there was no adequate explanation proffered for the omission to put it before the assessor and/or panel, this is likely to be relevant to the costs of the appeal proceedings in the court. And Price and Theodore is a good illustration of this. The court ultimately ordered for several reasons, including that part of the plaintiff's success hinged on a small fraction of the further evidence, that the parties would each bear their own costs of the proceedings.
Okay, interesting. So thanks, Katherine. So now I'm going to turn to Jackson and fire some questions again.
Sure.
So one common finding on assessments and by the courts is in relation to overcharging.
Yeah.
So can you give us a rundown on some of the recent overcharging cases?
Yeah, two cases in particular. The case of SCAF, which actually had as its central issue whether the Court of Appeal should order a stay of a payment of equitable compensation pending the assessment of this mostly successful appellant's costs. The facts were as follows. George, one of the brothers, lived in a house which he thought belonged to him. He brought up his kids in the house and he'd lived there for 34 years. He thought that it was purchased for him by his parents, but that it had been put in his brother's name because he was the less responsible brother. It was accepted that he had made significant improvements to the property. His brother Richard was on title and had been the mortgagor. And Richard, after 34 years, served an eviction notice. George made a claim for proprietary estoppel and other related relief, and he was successful at first instance after a 5-day trial. Richard successfully appealed, and the appeal went for 1 day. On appeal, while Richard was successful, George obtained an order for equitable compensation in the sum of $250,000 for the works he had done on the house. Richard sought a stay on the payment of the equitable compensation on the basis that his costs would outstrip the equitable compensation. He sought costs of around $350,000 for the trial at first instance and around $215,000 for the appeal. And in the court's determination, it said that the application for a stay was a non-starter because Richard would not be awarded his costs at first instance, and there was reasons given for that, and therefore that the equitable compensation amount would not be exceeded by any costs order. But in considering the costs of appeal, the Court of Appeal had real concerns about the $215,000 that were being claimed for the cost of the appeal. Those costs mainly related, it should be said, to counsel's fees. The court went into some detail to set out what the cost of an appeal ought be and found, quote, something has gone awry with these costs, end quote. And at the risk of earning the ire of my colleagues on the floor, it's a timely reminder that solicitors can seek assessment of their own barristers' fees. The other case is going back a bit further but still deserves some attention, and it's the case of Hartnett Lawyers and Bell. The question in issue there was whether the inherent supervisory jurisdiction of the Supreme Court extended to the power to order a solicitor to make payment directly to a party to the proceeding who is not a client. And spoiler alert, the answer is yes. The facts were as follows. Old Mabel Deacon Bell passed away, leaving a property to Mr. Bell. The property was subject to a mortgage in the sum, or a loan, in a mortgage in the sum of $30,000 to a Gwendolyn Deacon Bell, and that mortgage had been the result of earlier property adjustment proceedings. The mortgage was registered and included a clause to the effect that the mortgagor must pay the mortgagee's costs of recovery, extending to costs on a solicitor-client basis. Gwendolyn retained Hartnett Lawyers to seek possession and repayment of the loan amount. There was evidence of some delay as Mr. Bell did not immediately apply for probate of Mabel's estate. Hartnett lawyers commenced proceedings against Bell as executor, but then was informed that Bell was not the proper defendant, and so then amended the claim to name the New South Wales trustee and guardian as the proper defendant. The proceedings, critically, were undefended. The property was sold for about $375,000, and of that sum, about $25,000 went to the agent acting on the sale as commission. $39,000 went to Gwendolyn for repayment of the loan amount plus interest, and Hartnett lawyers was paid legal fees in the sum of $290,000. Importantly, in relation to the payment to Hartnett lawyers, Gwendolyn had signed an authority authorising that payment. Shortly after the sale, Mr. Bell was granted probate, and of course, as any equity in the property belonged to him, he was a little underwhelmed, to say the least, that most of the sale proceeds had gone to the mortgagee solicitor. He then sought information from Hartnett lawyers as to how those costs were incurred. And it seems initially Hartnett lawyers first threatened to seek an order revoking probate from Mr. Bell, and second, disputed the entitlement of the mortgagor to seek the information. That position was wrong by virtue of the operation of, I'm trying to skip ahead, is that going ahead? Oh, sorry. By virtue of the operation of the Queensland legislation, the Queensland legislation was the relevant legislation, notwithstanding that the case was being heard in New South Wales, and the corresponding provisions of the New South Wales Uniform Law are as follows, and Section 171 sets out at subsection 1C what is a non-associated third-party payer, and Section 198 subsection 6 of the Uniform Law gives the non-associated third-party payer the right to obtain on written request sufficient information to allow the third-party payer to consider, and if thought fit, to make an application for a cost assessment. This position was accepted by the solicitors after the intervention of the Queensland regulator. Mr. Bell then applied for cost assessment, to be noted on a party-party basis. Hartnett lawyers did not participate in the cost assessment, at least in part on the basis that it was not instructed to do so. The assessor assessed the costs at about $37,000, and Bell then demanded payment of the differential, i.e. the difference between the $290,000 and the $37,000. There was further correspondence and requests for extension of time by the lawyers, and by this stage it had been about 3 years since Bell first requested the information as to the costs. Bell then commenced proceedings, initially for monies he hadn't received, and the form of the pleading created some difficulties later. But ultimately the claim as advanced at hearing was an order for payment of those monies pursuant to the inherent supervisory jurisdiction of the court. And the Supreme Court found in favour of Bell and ordered Hartnett lawyers to pay the differential. The amount was assessed on the basis that Hartnett's reasonable costs were as assessed by the assessor. In so doing, Her Honour Justice Peden noted, a distinguishing feature of this case was that Bell was not the client of Hartnett lawyers. However, in exercising the supervisory jurisdiction, the court was not to be curtailed by technicalities, and the question was whether one of the court's officers, quote, should be held to ethical and honourable behaviour, end quote. Bell appealed to the Court of Appeal, and a number of grounds were advanced, all unsuccessful, but I just want to talk to two of the grounds. The first is that the supervisory jurisdiction did not extend to the power to order Hartnett to pay Bell. It was argued that the position of Bell was, quote, without precedent where the solicitor was neither a party to the proceeding or to the cost assessment. And Chief Justice Bell, lots of bells in this talk, usefully summarised the authorities in relation to the inherent supervisory jurisdiction, and I won't set out all the statements, but suffice to say that the Court of Appeal considered and rejected the position of the lawyers. As the appeal unfolded, it appeared that this argument morphed into a technical argument as to whether the inherent supervisory jurisdiction should be used in this way, where Bell had alternative rights under the legislation in relation to assessment. There had been a suggestion in some authorities that the inherent supervisory jurisdiction of the court is better kept within its known confines where there are statutory or other methods available to a litigant. But the court recited earlier authority to the effect that, quote, the true rule is that a court may exercise its inherent or implied powers in a particular case, even in respect of matters that are regulated by a statute or rules of court, so long as it can do so without contravening any such provision. The second argument advanced was concerned that Hartnett had charged Gwendolyn on a solicitor-client basis and the assessment had been on a party-party basis. Hartnett argued that the result was therefore incorrect as a matter of law and was procedurally unfair to him. And the Court of Appeal was less than impressed with this approach. It found that Hartnett would have been correct in that position if all the Supreme Court had done was adopt the reasoning or the determination of the assessor or had considered itself bound by the decision of the assessor. But the court had considered all the material available on the question of the reasonableness of the costs. And, quote, it was not a question of the solicitor being bound by the assessment where he was not a party to it, but rather a judge making use of such material as she had in order to undertake a quantification exercise in circumstances where the one party with peculiar and personal knowledge and the ability to explain the charges declined to take the few short steps to the witness box in order to do so, end quote.
Well, that certainly sent alarm bells ringing, doesn't it? Now, what about issues of over-representation and the retention of so-called dirty experts? And you might start by explaining to those that don't know what really a dirty expert is. Can they be instances of overcharging and disallowed on assessment?
A dirty expert is retention by a law practice of an expert who is not going to appear as a witness, but rather is retained by the representatives to assist with the representation of their client. These issues were considered in the recent case of Macquarie International Health Clinic and Sydney Local Health District. And the facts of the case were long, or the procedural history was long, in the sense that these proceedings had initially commenced in the year 2000. In 2010, Macquarie was successful on appeal in respect of liability, and special leave was refused, and the matter was then referred back to the Supreme Court for assessment of quantum. There are a number of further interlocutory stoushes, and in the to quote the cost judgment, in 2019, after nearly 40 judgments and 100 days of hearing, the Supreme Court awarded Macquarie, end quote, approximately $85 million by way of main profits. Now, the Court of Appeal in 2020, with due expedition, amazing expedition actually, heard 14 grounds of appeal over 5 days, and the end result was that Sydney Local Health District was successful and the claim was reduced, or the damages were reduced, to $14 million. After a consideration of the position, Sydney Local Health District obtained a costs award on the appeal. Those costs went to assessment and then review, and the review panel awarded costs in the sum of $1.2 million, being a reduction of about $30,000 from the decision of the assessor. Macquarie appealed to the District Court. There were many issues on appeal, but two of them were the issue of whether the costs of experts which the representatives had retained but who did not appear as witnesses on the appeal were properly disbursements, and the other was whether there were too many lawyers at the appeal. On the issue of disbursements, the court looked at the definition of legal costs within the meaning of the uniform law, and it's to be noted that legal costs include disbursements, but disbursements is not defined in the Act. So the court therefore looked to the authorities on what constituted a disbursement, and it had to look far back to the case of re Remnant from 1849, where Lord Langdale, Master of the Rolls, said as follows: "Those payments only which are made in pursuance of the professional duty undertaken by the solicitor and which he is bound to perform, or which are, and this is critical, or which are sanctioned as professional payments by the general and established custom and practice of the profession, ought to be entered and allowed as professional disbursements in the bill of costs." And this was repeated in the seminal work of L. Oliver from 1966, The Law of Costs. Interestingly, however, Oliver went on then to identify the classes of disbursements as he, in his very great experience, was able to ascertain. And the costs of an expert who did not appear in the proceeding, i.e. dirty expert, was not contained in that description. So the court also considered the case of Lewis and Doran, a New South Wales Supreme Court decision by Justice Hammerschlag, as he then was, and it's worth considering that case. In that case, the liquidators made claims against the former directors, and Doran was one of those directors. And during that claim, the company records, which are a huge number of boxes, were in the custody and control of the liquidators. In order to test the allegations that were being made against them, the directors had said that the plaintiffs ought to be put to the task of properly assessing the financial records of the company. But instead, Mr. Doran was given access to the boxes. Now, the defendants were ultimately successful, and Doran, in the costs application, or his solicitors, I should say, put on evidence about the huge amount of time he had spent preparing his defence and the affidavit for his lawyers. And his lawyers claimed this as a disbursement. And Justice Hammerschlag did not agree that that was a proper disbursement. So returning to Macquarie, clearly the time and costs of a dirty expert who is not a witness in a proceeding is in a different category to that of Mr. Doran. But ultimately, and this is to get back to Katherine's earlier point and the importance of preparing, in particular, the application for review, the court said, unfortunately, the question did not need to be resolved as the issue had not been put squarely to either the assessor or the review panel. However, the court went on to find that had it been necessary to decide, the court would have found the expert's costs to be disbursements. And still, in my submission, I think it is open to question whether the costs of a dirty expert, which have become so prevalent in modern litigation, is properly to be considered a disbursement. Second, on the issue of overrepresentation, it's to be noted that on the appeal there were 4 counsel, and for the majority of the time there were 2 partners, 1 senior associate, 1 lawyer and 1 paralegal. So ignoring the counsel's costs, this was about $100,000 in costs for the 5-day appeal. The assessor and the review panel both did not allow the costs of the second partner. The question in relation to solicitors attending on counsel in court, as is laid down in Re Quality House, a Supreme Court of New South Wales decision from 1969, quote, "would a reasonable and prudent but not overcautious litigant in all the circumstances engage the services of an instructing solicitor, notwithstanding the cost?" Having considered that test, the court rejected the argument that the appellant was overrepresented on appeal. The reasons were the assessor and the review panel had looked at the work that was claimed and had deemed it fair and reasonable. But principally the ground was rejected for the reason that this was mega litigation, which was reaching its crescendo in the Court of Appeal after some 19 years. And from that point of view, it was not an appropriate vehicle for a determination of how many lawyers is too many lawyers.
Interesting. You're certainly triggering me. I have some vague recollection back when I was doing legal cost consulting back in the 90s of having to give an opinion to a law firm where their client had, it was again large litigation, and the client's records were in such a state that they'd engaged separately a consultant and a team of people this was back in the day before things were being done so digitally, but they had a team of people to basically go through it, to do a first sort of pass, if you like, before, and then send it to the lawyers to do discovery inspections. And they had separately paid, so it never went near the solicitors' books, but separately paid for this work to be done. And a big argument opened up as to whether that was properly a disbursement, which they were trying to argue it was, when it never had gone through the solicitors' accounts, but nevertheless was an expense that the client had incurred. What I do remember of that, though, that it got right down to the fact that the consultant who'd done the work was also charging for the mints, as in the lollies that they had on the table while they did the work, which was kind of a red flag to everyone that maybe this was going to be a problem.
Yeah.
Now, moving on to a different topic, the High Court recently handed down its decisions in Burketu and Haskanovic and Hartnell, which established that firms representing themselves can charge for the time of employed solicitors. This seemingly flew in the face of the Pentelow-Bell decision and seems to restore the Chorley exception. Over to you.
Yes, well, it does and it doesn't. So Adanaskovic Hartnell made claims against its former client Burketu, and during that proceeding it represented itself. It was ultimately successful and it received judgment for nearly $1 million in fees plus a costs order. It then applied for assessment of its fees in the sum of about $500,000, and of that sum, $300,000 was for professional fees. Now, none of that related to the work of the partners of the firm, importantly, cognizant of the decision of Bell Lawyers and Pentelow, which had removed the Chorley exception. Burketu sought a decision by the assessor that at first instance, i.e. before he undertake the assessment, he was to determine whether the firm was entitled to claim for the work done by its employed solicitors. And the assessor refused this request, so Burketu then commenced proceedings in the Supreme Court seeking a determination of that question. At first instance, Justice Brereton declared that the firm was not entitled to recover the costs of the work done by its employed solicitors. And that decision was consistent with the Victorian Court of Appeal decision after Pentelow of United Petroleum and Freehills. The lawyers then appealed to the Court of Appeal, and it decided 2-1 in favour of the firm and allowed the cost of the employed solicitors. And Burketu appealed to the High Court. The High Court's decision unsurprisingly began with an analysis of the statute. And you'll see there under Section 98 that there is a wide discretion on the court, and that legal costs under the Civil Procedure Act include those matters identified there. And it reasoned that Bell Lawyers could be seen as an outworking of the indemnity principle of the earlier High Court decision of Catchier and Haynes. That is, costs are, quote, a partial indemnity for professional legal costs actually incurred in the conduct of the litigation. And this means, for example, that a firm cannot recover for works it agreed to render for free, and that the costs must be costs in the litigation. The general rule arising from that common law principle is that self-represented litigants cannot obtain compensation for their time spent in litigation. And prior to Bell Lawyers, there were 2 recognised exceptions to that general rule: the Chorley exception, which we've identified, which Pentelow overturned, and the in-house solicitor rule, which is the rule that a government agency or a corporation that was represented by its employed solicitor could obtain compensation for the time spent by that person. So Bell Lawyers had removed the Chorley exception, but it had specifically preserved the in-house solicitor rule. In the words of Justice Gageler, as he then was, the in-house solicitor rule could be seen as an outward working of the common law indemnity principle, i.e. these were actual legal costs in the litigation incurred by the employer. And the majority in Burketu found, in effect, that the in-house solicitor rule should extend to employed solicitors of a firm acting for itself on the basis that these were costs actually incurred by the firm. Now, in dissent, Justice Stewart made 2 points that are worth considering in the context of the ethical conduct of solicitors in practice. The first was that the court had removed one of the key bases on which Bell Lawyers was predicated. I mentioned that the High Court had reasoned that the Chorley exception was inimical to the fundamental notion of equality before the law. But the second basis on which Bell Lawyers rested was that it was important for representatives to be professionally detached in order to satisfy their obligations to the court. In his opinion, the majority view in Berkatu undermined that ethical foundation. The second related point was that there was a fundamentally important distinction between a firm representing itself and the employed solicitor of a government department or corporation representing his or her employer in litigation. In the latter case, the employed solicitor actually appears on the record as the solicitor in his or her own name. Whilst that did not alter the fact that the solicitor was an employee, nevertheless, in Justice Stewart's opinion, it brought into focus the independent role the solicitor was taking on. Justice Stewart agreed with President of the Court of Appeal Ward, who had been in dissent in the Court of Appeal, that the decision also undermined the equality principle in Bell Lawyers and placed, quote, solicitor litigants in a privileged position compared to other self-represented litigants. And in this respect, I should say the comparator question looms large. That is, who are you comparing the firm to? Corporations and government departments with in-house counsel, or the majority of self-represented litigants? It also, in Justice Stewart's view, had the undesirable outcome of meaning that a legal practice with employees could recover fees when a sole practitioner could not. But the takeaway, I think, is that the decision of Berkatu is unlikely to be revisited for a generation.
All right, and finally, a CPD on costs and ethics would not be complete without considering the dreaded personal costs orders under Section 99 of the Civil Procedure Act. So can you tell us about any recent cases in that space?
They send shivers down the spine. Now, I've put up Section 99 on the screen, and it's important to note that two things. The application for a personal cost order can be made on the motion of any party or on the court's own motion, but that the practitioner must be afforded procedural fairness on that question. Now, before I get into the most recent substantive decision on Section 99, there have been two recent decisions involving technical arguments made by solicitors to the effect that Section 91 of the Evidence Act precludes a court's reliance on the judgment of the underlying proceedings to prove facts in the Section 99 proceedings. And the two cases, one was in the Victorian Supreme Court and one was in the ACT Court of Appeal, and they're in the list of authorities. Both those applications failed, and the courts followed the earlier judgment of the New South Wales Court of Appeal in King and Miraniti. The Court of Appeal concluded that Section 91 was not engaged in proceedings where the court is exercising a supervisory jurisdiction under Section 99. So, back to the most recent substantive decision of Nahata and Robertson No. 2. The underlying facts of that case were as follows. As part of a DA approval, a condition of consent was that the plaintiff obtain a stormwater easement through the defendant's land. And the plaintiff sought an easement by way of Section 88K of the Conveyancing Act, and after the defendant refused to agree, the plaintiff commenced proceedings in the Supreme Court. The court dismissed the application, and as found by the court, the plaintiff, one, failed to provide the terms of the easement in registrable form as required by the Act, making the case doomed to fail. Two, failed to engage an expert to engage with the conclusions of the defendant's experts. And three, failed to, quote, make all reasonable attempts, end quote, to secure the easement or an easement, quote, to similar effect, end quote. At the conclusion of the hearing, the court gave notice to the plaintiff's solicitor to show cause why a Section 99 order should not be made. And I should just note here that as a matter of practice, at that point, the interests of the solicitor and the interests of the client diverged. And the solicitor, after some attempts at manoeuvring eventually obtained separate representation. So at the costs hearing, the court first ordered that the plaintiff to pay the defendant's costs on the indemnity basis, and then proceeded to consider whether the solicitor should indemnify the unsuccessful plaintiff. The court considered the relevant authorities and just some of the statements of principle, and I note the time, I'll just be brief. Quote, an order against a lawyer requires a careful balancing of the public interest in maintaining and nurturing a legal profession which provides vigorous representation for litigants in court, uncompromised by fear of personal sanctions for failure, against the need to maintain and nurture the obligation to provide independent advice to litigants and to give proper weight to the public interest in the efficient administration of justice. Secondly, there is no call to construe serious misconduct by reference to unsatisfactory professional conduct within the meaning of the uniform law. For a cost order against a legal practitioner to be made, quote, a causal connection, end quote, must be established between the client's loss, whether the opposing client or the legal practitioner's own client, and the legal practitioner's serious dereliction of duty, serious misconduct or gross negligence. Mere negligence or incompetence is not sufficient to permit or warrant the making of such an order. And a legal practitioner will not have acted improperly or unreasonably simply because he or she acts for a party who pursues a claim or defence which is plainly doomed to fail. Now, taking all of that into consideration, what was fatal for the legal practitioner in this case was that his client decided to give evidence against him. His conduct leading up to and during the trial had been breathtaking, but his conduct, as revealed by the evidence his client gave to his client, was atrocious. He told the client nothing further was needed in relation to the easement. This was despite the client asking the direct question when he saw the correspondence from the defendant's solicitor. He told his client that no expert evidence in reply was needed, and he told his client that there was no need to consider possible alternative easements. Now, in some ways, the case law is comforting, it should be said, because besides potential cost orders for delays and other faults, which are occasionally meted out to solicitors who've been in default, and I should just say the principle there is fess up and just cop it. But other than those smaller cost orders as to procedural matters, it is really only the most egregious examples that result in personal cost orders against practitioners. But ethical conduct of matters can avoid these issues being raised in the first place.
Thank you very much, Jackson. All right, we're now time for any questions, if anybody has any. Anyone in the room or anyone online? We have Jackie, I think, manning the online space. If anyone wishes to pose a question, are there any in the room? Yes.
I had a question regarding the decision. My one question effectively is, if the employee solicitor's costs can be recovered, is it based on the hourly rate of that solicitor, or is it based on the salary? Because wouldn't you be able to say that if it's the hourly rate of the solicitor, effectively the firm is still making a profit? Yes,
well, that's precisely, and the assessment is yet to be determined, as I understand it, so that may arise for further determination. But as I understand the practice is that the hourly rate is chargeable and recoverable even for, and Janet may have more up-to-date information on me, even for a employed solicitor of a government department or a corporation. So there is a recognition that there may be some windfall there for the corporation, but that is the way that the costs are assessed, i.e. you don't take a determination of what the salary is of that particular employee and then work out how much time they spent and how much time they would spend in a year working for the corporation. The common practice is that an hourly rate is just applied.
From what I understand, sorry to jump
yes,
in. From what I understand, that was considered, and the status quo in relation to Commonwealth Bank Hatsley is generally held, which is a market rate will be applied to that particular solicitor. They did look at it in 32, and I think, I can't remember the exact quote, but I think the position of the court was that If you think that the salary and the overheads are less than what that hourly rate is, I don't think that's sufficient in order to be a triggering mechanism for an inquiry to be brought down to look at that on a more kind of granular basis. And so, yeah, it's how it goes.
Okay. Is there any other questions? No? None over there, Jen? All right. Well, I'd ask you to thank our speakers. I certainly am pleased to see that obviously my legacy and costs is in good hands here on level 22, and I can safely go back to the Industrial Relations Commission knowing that that the new generation of experts in the space have taken over, which is terrific. So please thank our speakers and thank you for coming.